Greetings. My name is Jesse Weiner. I'm a co-managing partner here at YK Law in our Manhattan offices. Thank you for joining us today for this webinar regarding PPE. Who knew just a few months ago what that acronym even stood for? Nobody. But sadly, personal protective equipment has entered the lexicon of ordinary people everywhere. And while we won't here today be discussing the particulars of the pandemic, it's COVID-19, of course, that serves as the tragic backdrop to this topic, and which has caused this wildly high demand for PPE. A virtual new industry, mammoth in size, has essentially been formed, chaotically mind you, in just the last few months, whereby, again, due to such high demand, companies that have never produced PPE before are suddenly shifting production. Hockey manufacturing company Bauer, Brooks Brothers, and around 38,000 companies in China have recently applied for a license to produce PPE. Buyers who have never had to purchase in this quantity, or maybe not even at all, like state governments left to fend for themselves. New York Governor Andrew Cuomo has famously said that the situation is like 50 states bidding for the same goods on eBay. Brokers, who in ordinary times, ideally, would be acting on behalf of either buyer or seller, providing the value-add service of verifying the legitimacy of parties, the goods themselves, arranging logistics. Here, though, acting as pure middlemen, layers upon layers of them, who have entered the fray simply to make a buck. And it shows. Masks that would have gone wholesale for 50 cents months ago now can sell for $5, $6, $7 each. Ventilators that would have gone for $9,000 a few months ago now $75,000 or so. Transporting the goods is yet another issue. Passenger planes, on which almost 50% of air cargo travels, with those flights mostly canceled now, there's a bottleneck to get goods onto ships and on those far fewer planes as well, with the accompanying sharp rise in costs. But it gets even just a little bit worse, because what I've described here so far is a virtual perfect storm for scammers. Manufacturers that don't even exist, doctored video, forged documents and signatures, faked verification reports and other certifications, completely substandard goods, or maybe not even the goods at all, like the buyer who received a huge shipment of masks. Halloween masks. Mind you, it was never reported what kind of masks those actually were. But the real troubling side and very sad part about this all, of course, is that for PPE, it's really about saving lives. And that's, I guess, where we come in. I think that comes out a little more, we are here to save the world than it may be intending to sound. But in fact, we are here to help buyers and sellers know who they're dealing with, right? Create the contracts that will protect the parties and protect our clients' money via Escrow Services. That is indeed what we are here to do. So with that, let me introduce my esteemed colleagues and a special guest. Special guest is a doctor, Dr. Emily Kim, who I hope will give us a brief show and tell regarding these actual goods, because in fact, while we lawyers deal with these things every day, in fact, I don't really know, I thought this was an N95 mask just a couple of days ago when the doctor laughed at me. So now she's on call though, so whenever she has 5 minutes for us, she'll hopefully pop in and then she'll do her presentation and we'll let her go. As for the others, we have Laurel Grass, a partner and head of litigation at YK, who will speak about the incredibly important due diligence aspects of these deals. YK associate, Almas Bibi, who has become a consummate expert in the PPE business. She'll introduce us to the most common types of contracts that arise in these transactions, and we'll discuss the most salient points and clauses regarding those. But first, Director of YK Consulting and Head of PPE, Max Frankston, will share and describe for us the overall deal flow for one of these PPE transactions. So I'm going to buckle in, and Max, who I hope is now on. Is Max on? Take it away.
Max, you're muted. Unmute. Unmute Max, Jesse.
Where is Max?
Can you
There.
unmute?
Oh, okay.
There we go.
Hello, everybody. Hi, Max here in New York City. I have jumped into the PPE space. Can everyone hear me okay? Just a little thumbs up. Okay, great. So I have jumped into the PPE space, and now we are trying to join buyers and sellers of PPE. As intermediaries, we have become very important in transactions because we do due diligence on behalf of the buyers and sellers. We like to ensure trust across a transaction. So while I'm sure Laurel will talk about the importance of due diligence, the PPE space is fraught with fraud, and it's important for compliance reasons and all other legal reasons that we transact in a safe space. So here is how a deal flow works, just to give everybody an idea of what is involved in a PPE transaction. So in a PPE transaction, the buyer approaches an intermediary to seek stock, whether that be a mask, a gown, a glove, or anything else. And the buyer creates an LOI, a letter of intent, and then they show an LOA, letter of authorization, to seek the stock. And then the intermediary goes out to seek said stock. And there are two kinds of mask deals. One is spot inventory, which is OTG, on the ground in a warehouse, and the other is factory production. And a lot of deals are hybrids, where they are a combination of the two. So once an LOI is produced, then it's our turn to do due diligence and find out if the buyer is real and find out all of the people in the transaction. I like the analogy of the bookshelf. So we have a bookshelf where at either end is a buyer and a seller, and hopefully they're legitimate. Inside, there's a buyer's mandate, a seller's mandate. They act as agents. And then there are buyer's brokers and seller's brokers, and then there's an intermediary or two or three. And if it was a normal bookshelf, all the books would be normal and legitimate. But because of all the fraud in the industry, if you look a little closer at one or two of the books, you find out that the pages are ripped out, it's turned up upside down, and it doesn't belong there. However, somebody with improper intentions inserted themselves in on that bookshelf, and they are combining and collating all the documents across the transaction, and they slip themselves in. So when we do due diligence, that's how we find out if all of the collated documents in a letter of intent and letter of authorization type of package are legitimate. And oftentimes one party doesn't know who the other party is. So if we call for due diligence, they don't even know who we are because documents get passed around. And unfortunately, the problem in the PPE space is that docs get shopped around. So that's why due diligence is so important. Anyway, so there's the bookshelf analogy. And then there's a discussion of what are the most important PPE products. So typically it's 3M, N95, respirator masks, 1860. Nitrile gloves are also very popular as well. And I'm happy to take any questions if anyone has any. Is my audio?
We'll be taking questions. Just I kind of threw out on the side, and if they come up, I'll bring up as we're speaking or at the end of our little talk. Okay.
Okay. All right. Well, I'll just finish with one more statement. and that is I'm a bit conflicted to be brought into the PPE space because it does imply that I have to shelter in place longer. So, but you know, we're hoping that this will be a safe place to transact business, and we'll see what comes of it.
Indeed. Thank you, Max. Appreciate that. Right, and you may have heard also with the acronyms, always interesting to catch those, a lot of those in this business, both because of course there's international trade acronyms and others in the PPP specific. So maybe we'll have even a little game later on to see how many we actually know. So moving on, of course, the very important part of this PPE space, because there is so much fraud, and due diligence is very important to be weeding out, you know, who's real, who's not, and what's fake, what's not. So Laurel, if you don't mind speaking to that, please. Thank you.
Okay, thanks, Jesse. Good
Good.
job. So this is a crazy arena to be transacting business, and I'm just going to tell you a few little anecdotes to exemplify how this can be such a roller coaster. So we as attorneys are used to bringing people together. So maybe somebody wants to transact and buy a business or buy a house or whatever. You bring the buyers and the sellers together, you negotiate. The deal either falls apart or the people transact and do business. But in this landscape, there are so many people that want to commit fraud that it is absolutely crazy insane. So in the beginning, when we started researching and getting into this, we thought, well, we're dealing with an attorney. If we get presented with an attorney, then we were relieved. That's great, because this person has a license and they don't want to put their license at risk. But we discovered that they don't care. And we have found, I want to say, I hope we found all of the corrupt attorneys that there are, because I hope that other attorneys are just not corrupt, from all over the world, from the United States, from Canada, from South America. So if this is kind of like a primer in how to, so if you see an attorney, don't assume that they are going to behave properly or honestly. So there have been several attorneys that got arrested from, I don't know if you heard, but it was a big splash in the news about 2 weeks ago, that 3M fired 2/3 of their attorneys, and the FBI came in and arrested a good percentage of them. So there's just so much corruption, and it's just so insane. So we do due diligence, and we have a team to do due diligence, but you can't assume that people are who they say they are. The phone numbers actually reach them, the emails actually reach them, that they are the ones emailing. So what we have found the best way to do due diligence is to confirm who people are and just look at documents that you get sent for preliminary contract work and dissect them. And in the old-fashioned way, we print them out and then we just circle them. And I just have a stack right here that we've been looking at, and you'll see, like, for example, these just came in this morning. There is no date. Why would you write a contractual one without a date? And this deal has been closed. And this deal has, this has 1 million typos and doesn't capitalize names of countries. So when you look at documents, don't assume that because a CEO wrote them or an attorney purported to write them, that they're accurate. They could be just outright fraud. And I would say about 90% of the documents that we have are just outright fraud, or they were at one time written in order to be valuable and to transact business, but then the deal fell apart, but somehow the holder of the documents gave them to someone else and they became an asset to use for fraud in order, it's called shopping the deal. So the best way is just to proceed old school, make phone calls, look at documents, don't presume that people are who they say they are. I mean, just this morning, Almas and I were on a phone call for speaking to a couple attorneys, and the attorney said, yeah, I wrote that letter, but the deal is off. So I don't know how you got that letter since I threw it out. So anyway, so 3M, because of the Defense Production Act, The law involved here is anti-price gouging and the Defense Production Act. I'm not going to get into that and make you suffer, but that's why these deals are monitored by the Department of Justice and why 3M can't transact business independently in the marketplace because of the Defense Production Act. So the commission that one can get on a deal is 10%, and you have to be careful that it stays at 10%. And internationally, it can exceed 10%, but we don't do that as a policy. We don't think it's right because we want to get people's masks to people with, just fair pricing. So what I wanted to say about the price gouging and the Defense Production Act is that 3M evaluates what's called the IMFPA, which is the basic contract to finalize the deal to get people paid. Almas is going to tell you about that. If you don't sign that, then you don't get paid. And so for people who are intermediaries or attorneys for intermediaries, if you're not on that document, you're not getting paid. So 3M, if they see somebody who is, if 3M sees somebody who's a felon or who's on a list, they have a list that's like a no-fly zone. They won't let people transact business if they have been seen by 3M, not adjudicated in court, but if 3M sees improper behavior, they won't let them transact business with 3M anymore, or if they see that somebody has a felony. So you want to make sure that when you get the documents, you're doing due diligence, that you do a background check, and that even if you would be forgiving in their criminal falsity convictions that they have, you want to make sure that they are not put on the IMFPA or the deal will get dinged. So let me see what else I want to tell you. I'm over my time for 5 minutes, but I wanted to say 2 more things. So we do escrow in our firm, and Jesse handles our escrow, and we have like really, really good rates. Be careful if you see other firms and negotiate the rates down for escrow, because just they spend maybe an hour on it and then whoosh, they get like an enormous amount of money. So our rates are very low and very fair. And the other thing I wanted to say was that sometimes we see very bad behavior. People screaming, they're bullying, they use a phrase, oh, I just want to give money to you and pay for the masks. No, they have to proceed with the proper paperwork that Almas is going to tell you about, and don't be bullied into skipping a step, because for sure we have found that bullies are fraudulent. So the people that play nicely in the playground are the people that get to go to recess the next day. And that's how it is in the PPE world. I'm done.
Thank you, Laurel. Appreciate that. But did I hear you say that there are corrupt lawyers in Canada? I find that hard to believe for some reason. I don't know. I jest, of course. There's some nice people, right? You mentioned, of course, another acronym here, that IMFPA. Well, I'll just say, I'm sure I don't want to steal but the whole, I'll say, but anyway, so people know the Irrevocable Master Fee Protection Agreement, right? Which is kind of like to protect, basically a kind of commission agreement, protect people's fees. But also I see as a question here, we mentioned another acronym here, the BCL. How do you evaluate the authentication of what I assume here, Joy, means is the bank confirmation or bank comfort letter? I think you probably alluded to it, but how would you authenticate that, would you say?
So, well, that's a banking instrument, and you have to talk to the banking officer. And sometimes you will be given a code. Another thing I wanted to say is that we password protect all our documents, and we send them with a password. So the bank comfort letter, you need to talk to the banking officer, and we video those phone calls, or those phone calls, in order to make sure that we have a record of what we said and what the other person said. And another thing that Max does when he does due diligence is he forces the people to show their ID, and he presents his ID on video. And so that's an easy way. If people don't do that, then they can't proceed to the next step.
Got it. As you're saying, calling. Oh, go ahead. So Almas, why don't you take over? Thank you so much. Okay, Almas Bibi.
All right, sure. I just wanted to add something to the BCL part. So because it's a bank, they're very careful, very conservative. So you have to be careful who's authenticating the letter. So in order to authenticate the letter, you're gonna have to call the bank to make sure signed off on it can still attest that the funds are still there too many times. So for example, if you're an intermediary and you want to make sure that the funds are actually there, and if you call the bank to authenticate it, and then somebody down the line calls the bank again. So we had a few weeks ago where Laurel was writing the LOA, which I'll explain in a minute. It's a letter of attestation of funds. So she authenticated, she called the bank to authenticate, but they were expecting somebody else to call because the owner of the account gave them a different name, so that caused issues. So when you are doing that, you have to be very careful, and you have to make sure that the person that the bank is expecting to call to authenticate funds is the one calling. So a note on that. Now I can start on the documents. So I think I'm going to break it up into two stages of documents. The first stage of documents is the to begin the process, you need to present a letter of intent or an LOI and an LOA, which is a letter of attestation of funds, which is usually from an attorney. And so those are and sometimes people will present also a purchase order, but that depends on who the seller is. Some of them require it, some of them don't care. But LOI and an LOA usually are required documents to begin the transaction. So the LOI is basically a document from the buyer, the end buyer usually, or sometimes somebody's buying on behalf of somebody else. So the buyer in the LOI will say, this is the quantity I'm looking for, this is the product I'm looking for, and this is my max price, or give a price range. And then they will also have their attorney attest in a separate letter called the LOA that they have enough funds to cover what those two documents are then submitted. I'm going to focus specifically on 3M because that's mostly what we try to do, although sometimes people will go to private sellers as well. So once we receive the LOI and an LOA from somebody, usually a buyer or an intermediary, we do our due diligence like Laurel explained, and then we submit them to one of our trusted seller sources, due diligence. So these documents usually go through several rounds of due diligence. They eventually will get submitted to 3M. And once the documents are submitted to 3M or whoever the seller might be, they do their due diligence, and if they approve, then you go to the next stage, which is usually the attorney to attorney call, and you will do the price negotiations and things like that. The one thing to note, if you're going to be acting as an intermediary on a transaction, what you want to make sure is that one of the documents, which is called the IMFPA, which Jesse just described, the Irrevocable Master Fee Protection Agreement, is already in place before the attorney to attorney call happens. Because what happens is that sometimes when the seller's attorney and the buyer's attorney meet, they can cut everybody else out because they don't need you anymore. So if you don't have a signed IMFPA in place as an intermediary, you will be in big trouble. So that's something that you have to push for and get done as quickly as possible. As soon as prices are confirmed and parties are confirmed and you know who the seller is and you know who the buyer is, you need to get that document done right away. So the IMFPA will have the buyer's information, and usually it'll be the buyer paying the commission fees. So you have to make sure that the buyer signs this document. And it will also list any of the intermediaries on the buyer's side, on the seller's side, and then you'll have either the seller's mandate and the buyer's mandate. Usually there are a lot more intermediaries that are listed on the IMFPA, because especially for 3M, because they like to investigate everything. So everybody that's listed on the IMFPA will be investigated by 3M, and they will look into their background. So sometimes there's a lot of unsavory characters who bring us documents. We won't, transact with them, but sometimes you don't know. Like there was this one person who seemed to appear on every single deal. We did a background check on him, and he had the longest rap sheet you can imagine. So obviously someone like that will never ever appear on an IMFPA, because if they do, the transaction is not going to happen. So usually what happens is that groups of people who are on one side of the transaction. So for example, if myself and Laurel are if we're the buyer's mandate and Max and Jesse are the buyer's intermediary, Laurel and I will choose one person, for example, YK Law, to be our paymaster and be on the IMFPA on our behalf. And then we will have sub-fee agreements with YK or escrow agreements with YK or paymaster agreements with YK in order to get paid. So usually on the IMFPA, they try to limit it to up to 4 people so that, sorry, I got distracted by the notification, so that it doesn't get too crowded and too long. And then the other party that has this is the seller, just so you know that there is actually a seller, because sometimes you get to the end of the line and you realize that you're talking to a broker who is lying and they don't have a seller and they're using your documents to try and find a seller at the last minute. So that's the IMFPA. Once the IMFPA is signed, usually most people are covered. But if you yourself are not listed on the IMFPA, you have to make sure that you have a sub-commission fee agreement with whoever the payer group is for you. So that's the first document. So after the attorney-to-attorney call, the second document, and probably the most important document in the transaction for the buyer and the seller, is the sale SPA. The SPA will have all of the terms of the transaction itself. It usually has nothing to do with intermediaries. So if you're an intermediary, you probably never even see the SPA. Buyer's attorney and the seller's attorney, and they negotiate the terms. It will have the delivery terms, the payment terms, location, things like that, shipping, location, things like that. So all of the terms that are relevant to that SPA, and usually that's one of the last documents to be signed. And it's also at that stage that at the attorney stage, that the bank comfort letter, or sometimes they'll have a cage code in the US, at least for the government or hospitals, they'll have a cage code. So they might not present a BCL, but they might fund their cage code, and then you can authenticate that. So those documents are authenticated at near the end of the transaction. And once both the buyer and the seller agree on the terms of the SPA is signed, and then that is when the closing happens. Once the SPA is signed, they exchange probably the most important document from the buyer's perspective, which is the SGS inspection report, which whether the product exists, where it is, how many units, things like that. And that's the SGS. It's a company. It's an independent source. There's a couple of other ones, but the SGS seems to be the most popular. And so once the SGS report is exchanged, that's the final stage. The SPA is signed, and then the transaction is concluded. And so if you're using a paymaster, usually for the whole transaction, there will be one paymaster or escrow agent who will take all of the money. So for example, if you do a transaction for $1 million plus 10% commission, you know what, I'm not good at math, so let's do $100 plus 10%. So the buyers, or the paymaster or escrow agent, will receive $110 into their trust account, and then they will be responsible for distributing the funds to everybody down the chain. So the seller will get $100 for the actual purchase price, and then the $10, which is the 10% commission, will be split between all of the different intermediaries that are listed on the IMFPA. And so the escrow agent will have to take care of the escrow agreement or the paymaster agreement at that, and that's usually done by the lawyers. So for example, for our firm, Jesse handles all of our escrow, and he can do the escrow agreements in his sleep now because he's done so many of them. So I think that will be the last document in the chain of documents. I think that's all, unless somebody has questions.
Thank you for really getting into the details on that. My goodness. And of course, obviously, all of these kinds of agreements are to be handled by attorneys. I would not advise working on these kinds of things just on one's own. Very easy to be cut out of deals or otherwise. So please do contact us for those. I don't see any particular questions just now. I'm amazed at all that detail, but okay, please feel free to send those questions on over onto to the right side of our screen. But okay, then I will speak just for a few minutes. And thank you, Almas, by the way. Appreciate that. About escrow, one of the last parts of the deal. And so, of course, escrow, what is it? I mean, generally, I know I'm speaking to people who understand this mostly, but just for completeness here, we have escrow, right? Money held by a third party, i.e. me or law firm, on behalf of the transacting parties. In fact, more accurately, is to say on behalf of all the transacting parties. It's very important. And of course, mostly used regarding, most people probably know it with regards to real estate transactions, right? Buyer, not sure, they like the house, I'm very simplistically, like the house, not sure though, there needs to be some inspections being done. So money but seller wants to know, buyer serious, buyer puts money in this account run by a third party, right? A neutral third party, and house undergoes inspection. Okay, everything's good. And then that condition is met. The money then is released to the seller. And so it is with our PPE transactions. But who actually administers these usually? It's usually bankers or lawyers. And why is that? Bankers, of course, banks, they own and administer their accounts directly. So why not, perform the service for their clients? So they will generally do that for certain of their clients. But they, of course, generally have very high standards and make things very complicated, asking for all sorts of documentation. And contracts, escrow contracts generally run 20 plus pages. We lawyers, right, of course, want to be very careful, but generally have a little less rigmarole. And so we make things a little more smooth going forward. But also 2 reasons for lawyers. One, because lawyers, obviously the most trustworthy people in the world. When have you ever heard of an unscrupulous lawyer? Okay, I'm kidding, of course. But for real, one is that law firms must have trust accounts. They have operating accounts, but by the rules, they also must have a trust account. And these accounts are going to be tax-free and bank transaction free, bank fee free. And most firms, without any recorded improprieties, like YK, I'm happy to say, will have an unlimited transaction value. And you say, people have asked me, well, what is unlimited? And I have gone to my business banker and said, you know what? What is unlimited? I mean, 100 million, 100 billion? And they have said to me, quote, unlimited means unlimited. So I take them at their word for that. The other issue for us, though, is that lawyers, the second issue, lawyers are bound by rules of professional responsibility. And performing escrow services, I think in all states under professional rules, escrow services are specifically mentioned. So just as one example, probably the most important of the rules with regard to these rules for escrow, for instance, and these are from New York rules, by the way, as an example, a lawyer in possession of any funds or other property belonging to another person is a fiduciary and must not misappropriate such funds or property or commingle such funds or property with his or her own. I know you could say, okay, so the rules are telling lawyers not to steal. Brilliant. I feel so safe. Yes and no. What it is really saying, though, more importantly, is that the lawyer is deemed to be a fiduciary and have fiduciary duties to all the parties that have their monies in the escrow. Not, of course, even just to a certain person or entity that might be an already existing client of the firm. So that's the difference. So now we get to the PPE transactions. where escrow has been an important part of these very large dollar transactions. Now, the thing is, though, what we have to recall also, though, is that in March, April, and maybe even now to some degree, it's still a seller's market, obviously. So there are many deals where the seller says, hey, there are so many buyers, I just want the money, like all the money up front. I've heard of deals like this, and again, this happened, as I say, more on the earlier side, in the real heat of the need here in March and April, but with lots of money being lost and brokers like running away with the cash. Even in the seller's market, escrow is now a hallmark of almost all of these transactions. But what does that mean? So the escrow, there's going to be conditions for release, and those parts are kind of what's heavily negotiated, can be. So for example, just at one extreme, and again, staying in the PPE world here, at one extreme, for the benefit of the buyer, the goods maybe have to arrive completely at the buyer's location and checked, and then the funds can be released. Now, of course, that would have saved our hapless Halloween mask receiver, obviously. On the other hand, on the other side of this, would be that all the seller would have to do is that a bill of lading would have to be issued, that, by the way, just a document issued by a carrier, right, or once as an acknowledgement that goods have been received on the ship or plane. Similar, if you're on the European side, you most know about sea waybill or air waybill being issued. And then the funds would be released. But still the question would be, well, are the goods, when the goods are on board the boat or the plane, are the goods the property at that point of the seller or property of the buyer? Are we talking FOB, right, free on board, or CIF, Long Beach or something, where the goods are, therefore they become the property, they remain the property of the seller until they reach that destination. These are, not to get into the weeds, but these basically are the things that are negotiated with the parties, and generally not, as you know, generally not by the escrow agent, who's trying to remain sort of the neutral third party in this. And just one more thing I want to get back to, when I mentioned bankers and lawyers. Banks and other specialty escrow services companies generally charge a lot higher rates, as Laurel alluded to. And I'll just say, in case no one's asked, I'm surprised in the comments here, like, well, how much? Well, we start at 0.5% of the transaction value for escrow services. Most companies double that. And why do we do that? Because generally, look, we're not an escrow company, we're a law firm. And so we generally try to help our clients and others. And it's the escrow services are incidental to our other work, which is why our rates are so competitive, almost silly. But anyway, we want to help our clients and friends. That's all I have for escrow. And you know what? I think I'll tell you, unfortunately, I received a message from the doctor, from Dr. Kim. I've got multiple procedures this afternoon, 2 emergencies. Not looking good. I'm sorry to say we're not going to get our show and tell, it seems, so I apologize for that. But this is not an N95 mask, that I can tell you. Without the doctor, though, and we still, again, please feel free, send any questions, please feel free to send on. Otherwise, Laurel, Max, speed round. Oh, you know what? Well, wait, on one of these particular acronyms I wanted to ask about, the POL, that proof of, I don't think you mentioned that one in the deal flow, Max. Would you mind just talking about how that fits in to the deals briefly?
Okay, so an LOI and an LOA are provided from the buyer to the intermediary to do due diligence on, and in advance of an attorney-to-attorney meeting, POF is required. POF comes in 2 forms. Proof of funds could be a bank comfort letter, otherwise known as BCL, and it could also be a screenshot of somebody's bank account. Typically, it needs to have a lot of zeros in it. So getting the proof of funds is show me yours, no, I'll show you mine. And typically, a buyer doesn't want to show proof of funds till the seller can validate that the lot is live and real by showing SGS. So there's a bit of a chicken and egg, and it's a bit of a dance. So that's how the proof of funds works, because sellers don't want to transact with buyers who don't have the money, because it often happens they don't get the money because they don't get funded or whatever reason.
But how about the whole proof, the proof of life, which I think you mentioned it one day, and I was like, what the heck is that? I had to look that one up myself, actually, of course.
So POL indicates that an inventory is a live lot and can be offered up to transact.
Indeed, right. Like the actual video with like people maybe showing a date or a newspaper with the date with today's
Or
present.
somebody's code, a code they give them.
That's right.
So it's not just a generic video that can be sold for $3,000 online.
Absolutely. Well, I'm sorry to say I don't think we have any questions here, but okay, well, that's fine. Obviously, please feel free to get in touch with us further. This is a lot of what Max and Laurel and myself and Almas do these days, and happy to get PPE where it's supposed to go, again, to help people, protect people. And that's all for today. Thank you, Laurel. Thank you, Almas and Max. Everyone, and thank you all too for being out there and listening. Really appreciate it. Have a very good day.